Hi everyone, I'm Elaine, the host for today's interview at Law Insider. I'm also a legal and ethics commentator. Today we have invited Ms. Messia, who has just completed her College of Law course upon professional misconduct in breach of the legal profession uniform law. We have also invited Justice Dawson, the senior member in Ms. Messia's case. Originally born in Sudan, Ms. Messia migrated to Australia at the age of 14. She became a lawyer in 2008 and worked for short periods in a number of law firms before commencing her own practice in 2013. Ms. Messia, could you please tell us about your practice?
My practice mostly deals with family law, conveyancing, and will drafting matters. Most of my clients are from referral and Christian community. I have a good relationship with my clients, and my practice is heavily dependent on relationship and reputation.
Could you please share with us the background of your case around the professional misconduct and the charges?
It is about a conveyancing matter I carried. In 2015, on a purchase of a horse and land package, my client paid an initial deposit of $1,000 with a balancing payable subject to finance, which is due by 19 October. The financing was not yet approved by 13 October. However, the request time has passed and the contract became unconditional. I totally forgot this matter until I received a letter from the vendor's solicitor. I'm so panicked and request an extension of time. He agreed and required a $9,000 in deposit be paid on the same day. Then I made actually the money. I knew that I did not have sufficient funds in the client's ledger of her trust account for that payment to be made, and I knew that the money being paid would come from other clients' trust monies. I'm panicked and I'm too embarrassed to approach my client. I know the inappropriateness of my behavior, but I'm afraid that I would be thought to be incompetent by my community. Unlikely, the trust account shortages were detected by a trust account inspection, following which the Law Society suspended my practice certificate. The tribunal decided that I had professional misconduct pursuant to Section 300 of the Legal Professional Uniform Law. I'm reprimanded and I need to pay a fine of $10,000. The court also decides that I should undertake further education. I will enroll and complete a course containing obligations when dealing with receipt and payment of trust monies. I was worried about losing my current and future clients because of a small mistake, but I overestimated my ability to cover it. After cooling my mind, I felt really sorry for the clients whose money was misused by me. I sincerely apologized to them and realized my behavior is in breach of the ethical standard and the legal profession uniform law. I think the charge was fair. I should be punished for my actions because I breached the trust for my clients by using their trust monies without their authority. I had the legal training and I am a professional, so I should be held a higher standard of conduct. Again, I'm so sorry that my conduct throws doubt on the integrity of the legal profession and the legal system as a whole. Considering the breach of legal profession uniform law section 148 could result in 5 years imprisonment, the penalty in this case seems reasonable for me. I believe I could benefit from the further education.
Thank you, Ms. Messia. Now let's turn to Justice Dawson. Justice Dawson, what is the main logic behind the final decision and how were the rules applied?
Hello, I'm Senior Member Dawson of the Civil and Administrative Tribunal, speaking on behalf of myself and the 2 other tribunal members appointed to this case. In reaching our decision, we examined the legislation and found that Ms. Messia had breached several sections of the Legal Profession Uniform Law, of which a large number of sections are dedicated to the appropriate management of trust accounts and thus illustrates the significance of this responsibility within the profession. Section 138 states that a law practice must hold trust money deposited in their general trust account exclusively for the person on whose behalf it is received. Similarly, the trust money should only be disbursed in accordance with the direction given by the client. But as we know, Ms. Messia had used another client's trust money without their knowledge or authorization. Ms. Messia also breached Section 147, which states that a law practice must keep permanent trust records for all trust money received by the law practice. In breach of Section 148, Ms. Messia caused a deficiency in her client's trust account and without reasonable excuse also failed to ensure her clients were able to pay monies owed for the purchase of a property being managed by her. Ms. Messia also failed to report the unauthorized trust account irregularities to the designated local regulatory authority. In addition, the LPUL gives authority to the Legal Profession General Uniform Rules, which lawyers are expected to know and implement in their day-to-day practice. However, Ms. Messia showed a lack of understanding or disregard for a number of trust account-keeping rules. She did not keep adequate receipts containing the required particulars of the transaction, nor did she maintain a cash book for her general trust account, which sufficiently identified the matter in relation to which the trust money was received. Moreover, Ms. Masai did not satisfactorily maintain a clear trust account ledger containing separate details in relation to each person in each matter for which trust money has been received. Reconciliation of the trust records relating to each account within the general account was not adequately performed, and she didn't provide each person with a separate statement for each trust account, showing movement of the money and a record of the relevant dealings associated with that money. Consequently, Ms. Messiah fell well below the standard of competence that one would expect from an educated and experienced legal professional. We further considered authority from previous cases which shared some similarities with the present case, where a less severe penalty was given because of a number of mitigating factors, including that it was a relatively small sum of money. Each case was a one-off. There was no cover-up, the funds were replaced within a short period of time, the lawyer had no previous history of misconduct, and she showed remorse and was otherwise fit to practice. To determine whether Ms. Messiah is a fit and proper person to continue legal practice, we evaluated her conduct against that of a person of good fame and character. Notably, the original meaning embodied by the phrase fit and proper derives from the common law and can be separated into two branches. Firstly, being of good fame refers to a person's reputation, and in this case, Ms. Messiah had no prior history of misconduct. Secondly, looking to a person's character relates to their actual disposition and how their morals translate into actions. In particular, lawyers are expected to possess a strong commitment to honesty, which is also an essential component of building trust, the bedrock of a lawyer's trade. From the evidence brought before us, it was clear that she had not tried to cover up her actions, and further demonstrated good character by maintaining compliance with the supervision orders from the Law Society Council. There was no direct benefit to the respondent, which indicated that she was not motivated by personal gain, rather that she placed a high value on the relationships she has with her clients. While this may be morally acceptable between friends and family, lawyers have an obligation to conduct themselves in a way that is consistent with legal ethics and to demonstrate professionally sound judgment, owing their highest ethical duty to the court.
Why did you think this was a fair decision? And what were your thoughts about the lawyer's attitude?
Undoubtedly, it is not only important for lawyers to be fit and proper persons, but it is also imperative that practicing lawyers are competent to carry out their role, for the sake of their clients and the success of the legal system as a whole. Consequently, we also ordered Ms. Masai to undertake additional education to include a component of legal ethics as well as a trust account keeping course, to ensure that she understands her duty to the court as well as to her clients. Misappropriation is a grave matter and should not be taken lightly. However, in this case, we did not think that Ms. Masai's actions were so egregious as to warrant the maximum penalty. We were pleased that she admitted to the wrongdoing. She was honest and forthright in her complete admission. She maintained composure and accepted the consequences of her actions. This demonstrated good character. Therefore, we think she is capable of improvement and do not consider her unfitness to be permanent.
How did it compare to some of the other famous professional misconduct cases?
Okay, let's take a look at the Einfeld case and how it measures up against the present case. Einfeld lied under oath and signed a false affidavit to avoid paying a $70 speeding fine and losing 3 demerit points. It is immediately apparent that Einfeld was not honest and forthright about his misconduct. In fact, it was later discovered that he had a history of lying and submitted false statements to get out of past driving offences. The orders given to Einfeld were punitive in nature. He was struck from the roll, sentenced to 2 years imprisonment, and not allowed to apply for readmission. Conversely, Ms. Messiah was honest and admitted to her mistakes. Her affidavit contained a complete admission to the grounds set forth in the application and the particulars thereof. Honesty is an essential characteristic expected of a lawyer, so it is likely that this aspect of her character contributed to the lesser penalty and formed part of the reason that she was not struck from the roll. Mere negligence is not professional misconduct, but gross negligence or recklessness could amount to it. Upon examination, it's evident that both Einfeld and Ms. Messiah were influenced by the same enablers, overconfidence and self-serving bias, which allowed them to justify their actions to themselves. In the case of overconfidence, Einfeld knew the legal system and thought he could get away with it. On the other hand, Ms. Messiah thought she could hide the unauthorized transfers amongst other transactions so that it wouldn't be detected. For self-serving bias, Einfeld was motivated by protecting his reputation, hiding his misconduct, and keeping his squeaky clean reputation and public image. Whereas Nadia was motivated by keeping her reputation with her immediate community for the future success of her business. Interestingly, Einfeld's style of lawyering could be likened to the adversarial style, whereas Ms. Messiah seems to identify with the ethics of care model of lawyering. What this demonstrates is that all lawyers, no matter which model of lawyering they ascribe to, will face their own internal moral and ethical dilemmas. Accordingly, it is crucial for all lawyers to be aware of their strengths and weaknesses, and to make use of an ethical framework for addressing and tackling such dilemmas throughout their professional career.
Thanks, Justice Dawson, for sharing with us your thoughts on the case from a legal perspective. Now I'd like to apply the ethical decision-making framework for the analysis. In Ms. Messia's case, she wanted to help the client to proceed with the contract, to fulfill the contractual obligations, and pay for any outstanding monies before the deadline. While this outcome was eventually achieved, it was Ms. Messia's action towards that end goal that amounted to professional misconduct. While the decision made by Ms. Messia is reflected of the teleological theories, which is outcome-focused, a different decision might have been made if the Queensland Law Society's 9-step ethical deliberation process was followed. This is mainly because the 9 steps process will require Ms. Messia to take into consideration the other factors, including the interests of her other clients and the strict guidance of the source of authority. I will now go through the 9-step process in more details to explore the alternatives to Ms. Messia's decision. The dilemma that Ms. Messia faced was whether to use the trust account monies of other clients to fill the hole of one client. If she does that, she will meet the deadline for this client, however, by risking the monies of other clients, which are of less urgency. On the other hand, if she does not do so, she will risk damage her reputation as a competent lawyer and potentially the relationships with her client. Ms. Messia could be open and honest about her mistake, ask the client to deposit the money before an extended due date. The next step is to identify the interests of each stakeholder. The fiduciary relationship between lawyers and clients requires lawyers to act in the best interest of the clients and should avoid conflict of interest. In this case, Ms. Messia's decision should take into account the conflicting interests between the one client and the other clients, to whom the trust monies belong to. If their trust account monies are misused, there is possibility that when their payment was due, there is no sufficient trust account money for them to meet their contractual obligations. In addition, Ms. Messia needs also to balance her own self-interest on maintaining her reputation and relationships. The fourth step is to derive guidance from source of authority, which has already been covered by Justice Dawson. In considering the broader ethical considerations as a next step, it is important to keep in mind that legal practitioners arguably owe more responsibilities to the public, as they are in an advantaged position due to information asymmetry. In addition, the deposits into lawyers' trust account by clients illustrate a considerable degree of trust from the clients. Lawyers should not abuse the trust and advantaged position as a result of being a legal practitioner, since their own behavior might be seen by the public as representation of the entire legal profession, and might result in negative perception towards the profession as a whole. This is an example of how micro-legal ethics, which is the role and responsibilities of individual lawyers, can lead to changes to the macro-legal ethics. The impact to the reputation and trustworthiness of the legal profession should be a broader ethical consideration in all decision-making process, especially those that involve monetary transactions. The next step is to think about the resources that can be consulted. Ms. Messia could have consulted other lawyers who have had greater experience dealing with conveyance matters. Taking into account the broader ethical considerations mentioned above, individual lawyers can contribute to a more morally defensible and personally satisfying legal practice through resolving ethical difficulties together. The seventh step is to consider the consequences for each option. The breach of legal profession uniform law could amount to disciplinary actions, which could cause damage to Ms. Messia's reputation and relationships with her clients, especially those whose trust monies were misused. On the other hand, if she decides to be open and honest about her mistake, she might have a high chance of getting forgiveness, especially since extension was given and no financial loss would incur. After taking into account all these factors, it could be concluded that the best course of action would be to notify the client about the miss of deadlines, assure him that any late penalties have been waived, and ask him to deposit the monies at the earliest convenience. The trust monies of other clients should not be touched without prior authority. This is a logical decision to be made, as it shows the honesty of the lawyer by acknowledging that as human beings, people of any profession can make mistakes. Since the extension was granted and no late penalties would be incurred, the client is not facing any financial loss due to the mistake. Therefore, the negative impact to the relationship between lawyers and clients could be minimal. The exercise of this decision involves honesty, sincerity, communication skills, and the exercise of moral courage. In Ms. Messia's case, her decision echoed the ethics of care approach. This is demonstrated by the level of consideration she has placed on maintaining relationships with clients, as well as the fact that she tried to minimize harm by reallocating trust monies in order to meet more urgent needs. While these are seen as obvious advantages of this approach, it could be risky. If growth through relationships is central, morals and moral growth will become the subjects of relationships. This was proved by the fact in Messia's case that she felt embarrassed and panicked over a relatively minor mistake, and eventually surrendered the rules in order to maintain relationships. Ms. Messia could have achieved a more balanced approach through responsible lawyering, so that her decisions do not override her duty as a legal professional to maintain the justice and integrity of the legal system. So, Ms. Messiah, after reflecting on judges' consideration, the ethical framework, and the College of Law course that you just completed, what do you think a better alternative would be? How would you deal with similar situations going forward?
I would always keep in mind the ethical code and always keep professional. Especially after I finish the course, I'll be more familiar with my obligations when dealing with the trust money. If a similar situation happens, I'll definitely be a reasonable lawyer and honestly inform my client about the unconditional contract. Because mistakes happen, how to deal with mistakes is more important. I believe with that ethical behavior, I'll win back my client's trust.